myself Suresh Kumar Thakur, and the topic which we are discussing today, that is again a very important topic when we talk about the Hindu Marriage Act, and especially the conditions relating to the valid Hindu marriage under the Hindu Marriage Act 1955. तो एक हिंदू मैरिज के लिए इसेंशियल कंडीशंस क्या क्या हैं जो फुलफ़िल करना पार्टीज़ के लिए ज़रूरी होता है, वो आज हम डिस्कस करने वाले हैं. And section 5 of the Hindu Marriage Act, it provides for those conditions which are necessary for a valid Hindu marriage to be there. And when we talk about the marriages and the conditions of marriages, every kind of religion, कोई भी religion हो, Hindu religion हो या Muslim religion हो या Christian religion हो, कोई भी रिलीजन हो, किसी ना किसी तरह की कंडीशन जो है वो एक मैरिज के लिए, परफॉर्मेंस ऑफ मैरिज के लिए नेसेसरी होती हैं. उसी तरह से हिंदू मैरिज एक्ट में भी सेक्शन 5 कुछ एक एसेंशियल कंडीशंस ले डाउन करता है जो एक मैरिज के लिए वैलिड होने के लिए ज़रूरी हैं. एंड इट इज़ नेसेसरी दैट अ मैरिज विल ओनली बी ट्रीटेड एज अ वैलिड मैरिज अंडर द हिंदू मैरिज एक्ट if the parties they comply with the conditions which are there in section 5. Otherwise, अगर इन conditions को कहीं पे कोई violate करता है during the marriage, then a marriage may not be termed as a valid marriage. ये void marriage treat की जा सकती है या voidable marriage treat की जा सकती है. Now when we talk about the valid marriage, now all the legal consequences that flows from a valid marriage when a valid marriage is there, which may not be the case if we talk about a void marriage or a voidable marriage. Conjugal rights, mutual rights of the husband and the wife towards each other, they are such rights which flows from a valid marriage. Now again, अगर valid marriage नहीं है, कहीं पे marriage अगर void होती है ड्यू टू वांट ऑफ फुलफिलमेंट ऑफ सर्टेन कंडीशन, तो वो मैरिज जो होगा, तो जो पार्टीज़ के बीच में जो म्यूचुअल राइट्स हैं, दैट मे नॉट बी एंटरटेन्ड इवन इन द कोर्ट ऑफ लॉ. It was held in Leela Gupta versus Lakshmi Narayan and others by the Supreme Court of India that for the validity of a marriage, it is necessary that all the conditions under section 5 of the Hindu Marriage Act that should be fulfilled by the parties. Now coming to the conditions, that what are those conditions? The first condition under section 5 clause 1 that deals with the principle of monogamy, and it says that neither party should have a living spouse at the time of marriage. किसी भी पार्टी का, हस्बैंड का या वाइफ का शादी के वक्त, मैरिज के वक्त कोई लिविंग स्पाउस नहीं होना चाहिए. And that in other words that also means कि किसी की एक valid subsisting marriage नहीं होनी चाहिए. And when the Hindu Marriage Act 1955 was made in the year 1955, now polyandry and polygamy, both these kinds of marriages, they were prohibited by Hindu Marriage Act 1955. And polygamy and polyandry क्या होता है? Polygamy means where one husband is having more than one wife, 2, 3, 4 wives, that is considered as polygamous marriage. Polyandry, it means where one wife is having more than one husband, that is polyandry. Now both these forms of marriages, इनको जो था हिंदू मैरिज एक्ट 1955 जब एनफोर्स हुआ तो इनको abolish कर दिया गया. And now monogamy is the rule. And monogamy, it means one person, one spouse. That means one husband, one wife, or one wife, one husband. Now this is the principle. And now the failure of a party to fulfill this condition of the the monogamy, or if one person is having a valid marriage at the time when he enters into the other marriage, now that marriage will be void marriage under section 11 of the Hindu Marriage Act. Further, that person who goes through the ceremonies of other marriage while he is already being married, now that person will also be held guilty under IPC for the offense of bigamy under section 494 and 495. एंड सो ऑल्सो सेक्शन 17 है हिंदू मैरिज एक्ट का, उसके अंडर भी वो पर्सन बाइगैमी के लिए ऑफेंस के लिए गिल्टी होगा. एक और चीज़ जो यहाँ पे बहुत इम्पॉर्टेंट है, दैट इज़ द ऑफेंस ऑफ बाइगेमी दैट विल ओनली बी कंसीडर्ड टू हैव बीन कमिटेड बाय अ पर्सन where the first marriage of a person is a valid marriage. Now if the first marriage is not a valid marriage, now second marriage even if it is entered into by a person, वो marriage जो होगी bigamous marriage treat नहीं की जाएगी. Reason being कि पहली जो marriage थी वो एक void marriage थी, तो एक valid marriage के होते हुए दूसरी शादी करना that becomes an offense. Otherwise it's not the offense of bigamy. This was held by the Supreme Court in Santi Dev Verma versus Srimati Kanchan Prabha Devi. The second condition which deals with the validity of a marriage is the mental capacity. Section 5 clause 2 of Hindu Marriage Act that provides for this, and it lays down three essential conditions regarding this. First, it says that neither party at the time of marriage is incapable of giving a valid consent to the marriage due to unsoundness. Now it is a very essential element of the contract act that only that person can give the consent who is of the sound mind. Now same is the case here. If the marriage is there and husband and wife are there, they must be of sound mind so as to give a valid consent to the marriage. Secondly, it says that though a person is able to give valid consent to the marriage but is suffering from such a disorder, such a mental disorder, so as to be unfit for the procreation of the children. So अगर कंसेंट अगर दे भी सकता है कोई वैलिड कंसेंट, लेकिन इस तरह के किसी मेंटल डिसऑर्डर से अगर अफेक्टेड है कि वो प्रोक्रिएशन ऑफ चिल्ड्रन के लिए अगर कैपेबल नहीं है, so again that would be a violation of this condition. Third, it says that neither party should be affected by the recurrent attacks of insanity. Although this was abolished by the Marriage Law Amendment Act 2001, but just for the academic purpose I am telling this you that this was also a necessary condition under section 5 clause 2. Then after come the third condition, and that is with regard to the age of the parties. And as you know, under the Hindu marriages, now there is a certain prescribed age for the parties to the marriage. And Hindu Marriage Act 1955, it lays down that at the time of the marriage, the boy must have attained the age of 21 years and the girl must have attained the age of 18 years. And if the essential requirement regarding the age is violated by the parties, अगर एज का जो क्राइटेरिया है उसको कहीं पे वायलेट किया जाता है, दिस इज़ अ वेरी इंपॉर्टेंट थिंग टू रिमेंबर दैट इफ़ अगर ये कंडीशन एज की जो है इसको अगर वायलेट कहीं पे किया जाता है, नाउ द वैलिडिटी ऑफ मैरिज इज़ नॉट गोइंग टू बी इफेक्टेड. द मैरिज विल स्टिल बी अ परफेक्टली वैलिड मैरिज. ओनली व्हाट इज़ देयर इफ द marriage is contracted or marriage is entered into between the parties regarding the violation of this factor. There are certain provisions for the punishment for the parties, and section 18 of the Hindu Marriage Act, it provides that in such case a person or the parties may be sentenced to a simple imprisonment for 15 days and a fine of rupees 1000 can also be imposed on the parties. Further, such persons who officiate the child marriage, अगर कोई child marriage को, that means the person or the parties if they have not attained the age as required under this section, तो अगर कोई पार्टी अगर कोई और जो persons हैं उस marriage को officiate करते हैं, abet करते हैं उस marriage को, child marriage को, then they may also be held guilty under the Prohibition of Child Marriage Act 2006. And it also provides certain punishment for that case. A person may be sentenced to rigorous imprisonment for a term which may be extended to 2 years, and a fine of rupees 1 lakh can be imposed on such person. Next next essential condition is that the parties must not be within the prohibited degree of relationship. ये आपका सेक्शन 5 क्लॉज 4 में आता है ये कंडीशन. अब प्रोहिबिटेड डिग्री ऑफ रिलेशंस क्या होते हैं? दिस इज डिफाइंड अंडर सेक्शन 3G ऑफ द हिंदू मैरिज एक्ट. दो वी विल बी टेकिंग दैट इन डिटेल व्हाट इज़ द प्रोहिबिटेड डिग्री ऑफ रिलेशनशिप, वो हम आगे के लेक्चर में डिटेल में बात करेंगे. Here you just remember that there are certain close relation where the marriage is prohibited between two Hindus. हिंदू लॉ में कुछ एक certain close relation है जहाँ पे prohibited degree relations उनको कहा जाता है, जिनके बीच में marriage जो है वो prohibit की गई है. Like that brothers and sisters or the children of brother and sisters बात है, तो ऐसे कुछ एक relations हैं जहाँ पे marriage बिल्कुल prohibit की गई है. So these relations are considered as the prohibited degree relations, and if a marriage is entered into in such relations, prohibited degree relations, that marriage will be termed as a void marriage under section 11 of the Hindu Marriage Act. One thing which needs to be remembered here under section 5 clause 4 within the prohibited degree relation, it is that if the parties, if the custom of the parties, any of the party, if the custom permits that such marriage can be entered into, अगर कस्टम कोई है किसी पार्टी का जो ये परमिट करता है कि उनके प्रोहिबिटेड डिग्री रिलेशंस में मैरिज जो है वो वैलिड मैरिज होती है. नाउ इन दैट केस इफ द पार्टीज दे आर एबल टू प्रूव दैट देयर एग्जिस्ट सर्टन कस्टम इन विच दे आर अलाउड टू entered into such marriage, only in that case such marriage will be treated as a valid marriage. Otherwise the marriage will be treated within the prohibited degree relations, the marriage will be treated as void marriage. This was held by the Supreme Court in Shakuntala Devi versus Amarnath. And the next and the last condition under section 5 that deals with the prohibition of marriage within subinter relations. Subinter relations, they are defined under section 3F of the Hindu Marriage Act 1955. Again in detail we will be discussing the subinter relation as well as the prohibited degree relations in the coming lectures. Here now subinter relation, they are such relation, such close relation based on blood. जो blood relation है और कुछ एक नज़दीकी रिश्ते में आते हैं वो आपके subinter relations में आते हैं. And again here the marriage between two persons who are subinda to each other, now that is completely prohibited under the Hindu Marriage Act. And again the consequences are the same what are there if the marriage is entered into in the prohibited degree relations as well. तो अगर subinda relations में भी अगर marriage दो person आपस में करते हैं, that marriage will be treated as a void marriage under section 11 of the Hindu Marriage Act. The same condition regarding the custom is there which we have discussed earlier. अभी जो हमने डिस्कस किया कि अगर कोई कस्टम है पार्टीज़ का जहाँ पे ये प्रोवाइडेड है कि अगर उनके बीच में ये इस तरह की अगर इवन इफ टू पर्सन्स दे आर subinda to each other, so if the custom permits that such marriage can be treated as a valid marriage, now there is no such prohibition. Even in that case that marriage may be treated as a valid marriage, but that is only the case where it is proved to the satisfaction of the court that there exists certain custom which permits for the validity of such marriage. Now these are your 5 conditions for the validity of a marriage under the Hindu Marriage Act. Thank you.